viewed with favor by the commission, because you have an opportunity to look at those sort of intangible kinds of qualities that you might not otherwise be able to really put your arms around, and you get it from the sense that somebody who was on the other side is actually saying nice things about the opposing counsel. So I think that's very important in terms of the endorsements. Keep in mind, as I said, that sometimes we find situations where people have lots of letters in the file, and they think that's cutting the mustard. That's doing the thing, and it's really not, because you might have 20. One person might have 20 references, and another person might have 3, and those 3 might end up being or be carrying more weight than the 20 that the other person has. So as you think about who might be able to give you a reference, keep those kinds of things in mind, because the commission members certainly do. One other point I'll make in terms of the opening remarks is don't sell yourself short. Grace talked a lot about the different kinds of things that the commission looks for. We often think that when we're considering a particular move, a particular position, are we qualified for it? Do we have this kind of experience? And we have in our minds sort of our own understanding, our own sense of the particular types of qualities that you have to have. And so I often heard when I was on the commission, oh, you all only look for prosecutors, or you all only look for people who, have lots and lots of trial experience. Corporate lawyers are out of the mix, or, private practice folks are out of the mix because, they're not in court enough. And we sort of develop this mindset about what it takes to be a judge. Sometimes we need to step out of that box, because there are other things that are important. And I know when I was on the commission, just as Grace has said, and I served under both Judge Sullivan and Pat Worthy, who was the chair of the commission prior to Judge Sullivan. And we made a big effort to go out and say to folks, we are looking for a variety of people to be on the bench. And the hardest thing was to get people to understand that was really true. And it was like a self-fulfilling prophecy. People didn't believe it. So the prosecutors were the ones who applied. The prosecutors got selected, and then people say, you only pick prosecutors. Well, we can only pick the people who apply. So we really made an effort. I know during my tenure on the commission, as I said, I sat on a number of panels to really go out there and say, please come. We're looking for people from the private sector. We're looking for solo practitioners. We're looking for people who have different kinds of experiences, because we really believe that that's what would make the best bench. A collection of judges who came from different perspectives, who had different legal backgrounds, and who could bring different and unique perspectives to the bench. So I say, and I emphasize, don't sell yourself short. And I will give this last anecdote. That's a personal anecdote, and I will thank Grace Speights, because she was on the Federal Judicial Nomination Commission when I came through as applying for U.S. Attorney, and ultimately became the U.S. Attorney. So I'll thank Grace over here on the side. But I remember when I was applying for U.S. Attorney, one of the things that sort of was on the mind was, most U.S. attorneys, virtually all U.S. attorneys, came from a background that was essentially criminal law, particularly in the District of Columbia. My background was civil. And I remember when I applied, people were saying to me, like, well, what about it? You're like a civil lawyer. This doesn't happen, And I had convinced myself that the issue wasn't whether I grew up on the civil side of the house or the criminal side of the house. The issue was whether I thought that I had what it took from a skill and other background to be an effective United States attorney. And I just went in hoping that I would be able to convince the Judicial Nomination Commission of what I believed. And fortunately, I was able to do that. And I give you that anecdote only to say that sometimes we sort of put ourselves in little boxes. and we have a little cabin, and we stay in that cabin, and we say, this is all that I can do. Because those other positions and those other opportunities require something that I don't have. And I think we need to think outside of the box sometimes and think, be introspective and think about what is it that I have that I think that I can give to this particular position. One, do I have a passion for it? Am I really interested in it? And what is it about me, about my background, about my experiences that I think I can offer? And then you go out and you try to convince the commission that really that is something that they should take note of. Turn the table around a little bit. Think about what you have to offer, and then go out and try to convince the commission that this is something that you really want on that bench. I'll stop.
Holly, I forgot one important thing before John talks about the federal process. I think it goes without saying, but I want to mention it. In addition to submitting an application, you also have to sign a release that allows us to get a credit check, records from the FBI, the Metropolitan Police Department, the Internal Revenue Service, and when we'll start talking about where people get hung up on things, I'll say it again, the Internal Revenue Service, the Office of Bar Counsel, as well as the Grievance Committee of the U.S. District Court.
And John, why don't you tell us about the process for the U.S. District Court?
Thank you, Holly, and thank you to the Women's Bar Association for the opportunity to attempt to demystify the federal process, which is a bit more mystical, I think, than the local process. Indeed, sometimes it does seem like part politics, part swap meet, part astronomy. But there is a process, and it's not a statutorily derived process. It really came out of Congresswoman Norton's work on behalf of the residents of the District of Columbia to seize every opportunity to make sure that D.C. residents have the same input into the federal process that every other American has. So when President Clinton became president, she decided that because the District of Columbia doesn't have senators, we have a non-voting delegate, as you know, in the House of Representatives, that why shouldn't she ask the President of the United States to grant the District of Columbia the same senatorial courtesy that we would receive if we had senators. And what that meant was that because there are, for example, so many district court judges around the country, that the President can't possibly, sift through all of that and choose those folks without some help. And so senators play a very important role. The senators make those recommendations to the President, and generally the President follows those recommendations. Congresswoman knew that and decided to ask for it, and Clinton, to his credit, granted it to us as district residents. So she set up a commission to help advise her in the role of the senator to make these recommendations. And in the Clinton administration, as Judge Huvelle, I think, mentioned, 9 of the judges chosen came through that process, including Judge Huvelle. And I think even today, folks talk about that first Norton Commission as doing some terrific work.
I think so, John.
Absolutely. Absolutely. I wasn't on it.
I think so too.
I wasn't on it the first time. But if you look at the quality of those judges, including the judge sitting to my left, it's really important to see what happens when you involve the local district in making those decisions. Now, in the Bush administration, when the party not of the party of the senator is in power, it's a consultation role. And so, again, Eleanor, to her credit, knowing that she wouldn't have full senatorial courtesy, went to President Bush and asked for the senatorial courtesy that a senator of the opposite party would get, and was granted that. And in fact, she was consulted, by the White House on judicial nominations. Of course, we weren't able to influence them in the way that we would have been able to influence them had we been the party in power. But it was a good relationship. Then, of course, President Obama came in, and she again asked for full senatorial courtesy and was granted it. So she has now constituted a 17-member commission. I am one of the members of that commission, and it is an amazingly diverse commission that she's put together in order to